All right, we're almost there. Okay, so we're recording with Zoom. It's live on YouTube. I think we're good to go. So this is cause number 2017 L6942 in the matter of the marriage of Eileen Hardis and Eugene Hardis Jr. We have everyone announced who's here.
Connie Ann Ravdol, present for Eileen Hardis.
Hey, wait a second. Wait. Now we got a problem.
I'll make a note of that. Show us that step.
All right, so I think we got that fixed. So we'll go back and have everybody announce who's here.
Connie Ann Ravdol for Eileen Hardis.
Good morning, Your Honor. My name is Aaron Reimer. I'm present on behalf of Eugene Hardis, and I am standing in for Susan Ohl, who is attorney of record for Mr. Hardis. She has filed a motion for continuance for today's hearing.
Okay, and so Mr. Abdel, do you need anybody sworn?
No, Your Honor. I think it's a petition. It's a petition for entry, so I don't know that we have testimony.
Okay, and then Mr. Reimer, any testimony?
No, Your Honor, just myself as an officer of the court.
Okay, all right. So we're here for the motion for confirmation of the award, and so Ms. Ravdel, you want to proceed?
And Your Honor, we have filed a motion for continuance. May I argue that motion first?
Yes, you may.
Your Honor, I would argue for three specific points why the motion for entry should not proceed. One is that this motion was actually filed, or petition rather was filed by Ms. Ravdel in January. My client was not served until the 21st. Ms. Ohl immediately contacted Ms. Ravdel and notified her that she had a pending medical appointment that was set for this morning, asked her to reset it. There was a verbal agreement between Ms. Ohl and Ms. Ravdel on the 23rd, in which she had agreed to reset the hearing. We received an email from her paralegal yesterday at approximately noon rescinding that agreement. So on that basis alone, we would request a continuance. Second, Your Honor, the relief that has been requested today by Ms. Ravdel is essentially the same relief that she is requesting in her petition. Pursuant to Texas Rules of Civil Procedure 245, a party is entitled to reasonable notice of a final trial, reasonable being at least 45 days. We would request that since the relief is the same in the motion as it is in the final relief that's being requested, Your Honor, that this hearing be reset. And then finally, this hearing is related to a arbitration that occurred arising out of a divorce decree. And if I can just give a brief timeline, Your Honor, the parties entered a decree April 11th of 2019. Over a year and a half later, there was an arbitration related to the sale of property that occurred on November 6th of 2020. The parties received that arbitration decision and award. On the 12th, which was 6 days later, we filed a response to the arbitrator requesting modification and clarification. That response, Your Honor, is permitted under the rules for arbitration, specifically CPRC 171.054. A request for modification has to be made within 20 days. Ms. Hardis's counsel, Mr. Fagan, at the time, similarly filed a request that was on November 12th of 20. Those requests have not been ruled on. On December 10th of 2020, we received an email from Mr. Fagan's counsel requesting our signature on an order, and we responded to that the following day, or Ms. Old did rather, that said, I'm not inclined to sign off on an order. Hopefully we'll get a response from Ms. Thompson soon. So that order has not been resolved. We did not hear any further response from Mr. Fagan's office in the intervening 18 months. Your Honor. And it was our understanding, at least as recently as the summer of 2021, that the parties had been able to work out most of the issues amongst themselves. It wasn't until this petition was filed at the end of January 2022 that we were even aware that there were any outstanding issues that needed to be resolved. Upon receiving this, we immediately contacted the arbitrator, Ms. Thompson, and asked her to set a hearing and to rule on the outstanding motions filed by both parties related to her arbitration award. In the event she either refuses or does not rule, one of our bases, Your Honor, with respect to Ms. Thompson, is that we believe she's exceeded the scope of her authority, and we would be filing with this court a motion to vacate. However, I think it's premature for us to file any motion since she has not ruled on the motions that are currently pending with her. So for those three reasons, Your Honor, we would request that the court continue the hearing set for today.
And what are the outstanding issues in front of the arbitrator?
Your Honor, to be candid, I'm not specifically aware of all of the issues because I was not involved in that part of the case. Ms. Hull and Mr. Fagan were related. I know one of the issues has to do with a piece of personal property that was specifically awarded to him in the decree, and then divested of him by the arbitrator in that arbitration from November of 2020. We believe obviously she exceeded the scope of her authority by divesting her of that property. There are other issues related to transfers of personal property, but I'm not familiar, Your Honor, with all of the details.
And then has any hearing date been set with the arbitrator?
No. We reached out yesterday to confirm that date. She has not responded. We, based on Ms. Ravdell's representation that this hearing would be reset, we had not contacted the arbitrator immediately.
Which is I'd like to respond to, and I would appreciate a chance to respond when.
Yes.
Mr. Reimer,
let me let Mr. Reimer finish, and then Ms. Ravdell, you'll be able to respond.
Yeah. So when it became apparent that today's hearing was not going to be reset, we reached out to her. That was yesterday afternoon. Ms. Ravdell's office was included on that communication. Ms. Thompson's office responded to confirm that they had received the email, but they have not provided any dates at this point.
Okay. All right, Ms. Ravdell.
Thank you, Your Honor. Good morning. I believe that Mr. Reimer has gone way beyond the motion for continuance and has opened the door into arguing against, I suppose, our actual request for relief that he claims he needs additional time to respond to. The motion for continuance was filed, and after various emails between myself and Ms. Earl, there was a phone call between myself and Ms. Earl day before yesterday for the first time. So as far as immediately reaching out, I'm not really sure about this officer of the court's characterization. Secondly, regarding our claimed agreement, there was no agreement. What I had said to Ms. Earl was that I will check with my client about her position, and I might be able to sell to her an understanding of a continuance if we can get the hearing earlier than 30 days out, etc. So we had a conversation during which I pointed out to Ms. Earl two things. One, a problem with her pleadings, which recite that it's a modification, which it isn't. So apparently the system, she said, at her office was not working, and she was answering or reviewing pleadings on her phone. The system seems to be quite fine at Mr. Reimer's office if he shares it with Ms. Earl. Second, she had claimed two reasons why she was not able to appear today. One was that she was in a hearing, and two was that she had doctor's appointments. Apparently, the fact that she wrote in her motion that she had a hearing, I was about to ask the cause number and the court where that hearing was occurring, because we have a problem then about those representations. And I suggested to her I really didn't want to make that an issue in a courtroom. And then finally, Ms. Earl said that she needed time to prepare for this hearing and had mentioned various issues she had with the arbitration, at which point I reminded her that there was no appeal filed regarding the arbitration. It has been a considerable amount of time. And part of the issues between the parties who are in fact not resolving anything on their own is that her client, Ms. Earl's client, has failed to pay a significant amount of money that is due our client. And there were significant delays and a lot of dilatory tactics throughout since the filing of the petition for divorce. And our concern is that this is yet another one, and Ms. Earl is a vehicle through which Mr. Hardis is visiting this delay upon our client. So given that they had actually filed pleadings and the issue about their answer date is not really valid, I would argue, we're simply asking, have they read the proposed order against the arbitration award? I have not yet received a response to that particular question, which is the only inquiry my understanding is that this particular hearing involves. It's a 10-minute process, and Ms. Earl was the attorney of record during the divorce. So she told me that she had slept since then and needed to review her file, but needed to prep to see, at which point I asked her, well, did you even at least read our proposed order? So that brings us to today, where we're asking for the court to enter our order, which comports with the arbitration award. And the rest of the arguments are all ancillary, I would argue, that they go beyond the scope of the purpose of this particular hearing.
And so, Mr. Reimer, have you received the proposed judgments?
We did receive a proposed order. We received it back in 2020, to which Ms. Earl responded that she was not in a position to respond to that order then because Ms. Thompson had not ruled on the request for modification that had been filed. We received no further communication from Mr. Fagan or Ms. Ravdell's office after December of 2020. None. It wasn't until this motion was filed in January where they claimed that they have an order that needs to be entered. We're not opposed to entering the order, Your Honor. What we're opposed to is entering an order prematurely prior to the time at which Ms. Thompson has had an opportunity to consider the argument of the parties. I have in front of me Ms. Earl's letter dated November 12th of 2020 and Mr. Fagan's letter dated November 18th of 2020, both of which are requesting that Ms. Thompson clarify certain portions of her arbitration award.
We're not aware that we requested any clarification. We're simply understanding that we sent the proposed order for a signature, but there was no appeal of the arbitration, nor was there any process to set it aside, etc. So I'm not really certain where any of this is coming from, and it's certainly not part of a motion for continuance. That's an argument against our overall underlying pleading. So it seems like Mr. Reimer is arguing both, and I'm not sure where we go from there.
It certainly is relevant to the continuance because if we do not have a final arbitration award, then it would be inappropriate to have a hearing on entering that award.
Arbitration award, and there was no appeal.
There was a motion that was filed under Chapter 171 of the Civil Practice and Remedies Code, requested by both parties filed to modify the arbitration award. Those have not been ruled on, Your Honor.
There was a letter written for clarification of various points. There was never any formal process engaged in to modify, amend, appeal the arbitration award, and the time for doing that is long since passed. We are simply asking for entry of an order, and what I suspect is that Ms. Earl is afraid that what comes next, as she stated to me, is a motion for enforcement. And so we're trying to, I guess, block that kick as best we can, and this is not how you do that.
Okay. Well, I would like to see some final answer from the arbitrator if there's a question about her award. And so I'll grant a short continuance to confirm that with the arbitrator. If you want to look at schedules.
I'm available on on the 4th, Your Honor. Do we only do these hearings on Fridays?
With Zoom, we can do it just about any day.
Okay.
So Mr. Reimer, do you think March 4th? That's a week. So is that going to be
I mean, I haven't received a response from Ms. Thompson's office, so I'm not certain how quickly we can get in with her.
Try as best we can. I'll help you light that fire if you like. If Mr. Hardis wants to pay for the arbitrator to make another ruling, that's fine. And Susan had said to me that she was available on the 4th.
All right. Well, is that,
I appreciate counsel answering for me, Your Honor. Again, I'm not certain whether or not Ms. Thompson is available and can respond to this issue within a week. If Ms. Ohl is available on the 4th and we would like to set it, that's fine. But I'm not having a response from Ms. Thompson. I'm not certain that we will be any farther down the road on this process in a week.
Well, how about if we reset it for the 4th and see what we can do about getting an answer from Ms. Thompson? And that way we're sure at least that we're not complicit in dilatory tactics.
so why don't we just set it for is either 9 o'clock or 1:30? Is one time better than another?
Either one works for us, Your Honor.
So why don't we set it Friday the 4th at 1:30?
Yes, Your Honor.
Yes, Your Honor.
The same Zoom information, or do we need to get new?
We'll probably send a new Zoom invite.
Okay,
But again, so Friday, a week from today, Friday, March 4th at 1:30.
yes, Your Honor.
And
Are we excused?
Okay.
you're excused.
Thank you.
Thank you for your time, Your Honor.
Thank you.